So I've created a form that all sellers need. You should probably get one tailored to your state. I'm a California attorney and a broker. All sellers need it, and all listing agents need a form like this if they're going to allow, if they're going to be part of a transaction in which a buyer agent is compensated. And let me be very specific. In my mind, it's any transaction in which the buyer agent is a National Association of Realtor, and those buyer's agents forced their buyers to sign a form that said they will get compensated if they help them buy a form. And I'll tell you in short, the reason is because this locks in. It's now institutionally locked in price fixing and steering. Now, price fixing, realtors are allowed to say they don't want to work for no money, without compensation. But it does lock it in, but is it illegal? I don't know. But the steering, absolutely institutionalized because of this form and because of the way the NAR, in my opinion, it seems like they prevailed upon many MLSs and they're fighting lawsuits to free licensed real estate agents from NAR. Like a licensed real estate agent, if they really thought about this, was like, if they want to work with buyers, I can't follow these forms. The DOJ's told us this is potential price fixing. This is a potential criminal steering. I cannot use that form. But then they won't have access to the MLS the way it's being purported out now, because they're saying MLS participant, whatever that means. But as I've gone through it and I tried to study it, it seems that they're trying to say that if you get your data or you're paying access to the MLS, you have to make your buyers agree to pay you ahead of time. To me, that seems like a conspiracy. It seems like a RICO issue because there's unethical and criminal behavior potentially tied up with that. Now, am I making this up? No, I'm not. I put out videos about this, and I think that's why DOJ told California they can't give forms to listing agents, because listing agents, they're not, unless their lawyers aren't licensed to explain this to their clients. But when I typed in let me see if I can make this bigger. When I just asked Google about it, and they brought up the AI, I said, could you tell me about the Sitzer-Burnett case in which the DOJ filed a statement 5 days before the settlement, and they objected to part of the process. And the DOJ argued the settlement doesn't resolve current or past antitrust violations. That's sort of the major one would be about price fixing. And I have a process that's free if people want to watch my videos or they want to go to my course, that I explain you should have a two-step listing process. A buyer, a seller, and a listing agent should not discuss levels of compensation prior to the home being listed. In other words, initially that discussion needs to be about what the listing agent charges and what the seller wants to pay. And the idea is that if you want to offer buyer agent compensation later, we'll discuss that at the right time after we get it listed. I can't, if you're a listing agent and you want a future and you don't want to be involved in these class action suits, you cannot say, I want you to offer 2 or 3 if you want to get this house sold. I wouldn't even talk about what's prevailing in your market right now. I just say, I don't want to get you in trouble. I don't want you to be in trouble. Let's get the property listed, and then I'll let you offer whatever you want after consultation. And that's what this form is about, that I'm giving out for free. All right? This is why you want to follow this two-step listing process, and you want the seller to acknowledge, this should be bigger for purposes right now, you're going to want the seller to acknowledge that they understand you're not requiring them to offer compensation. That's scenario 1. It's not going to be offered for now, but when they want, they could either agree to make it they could agree to negotiate it when requested. They could say, yes, we're offering 2 or 3%, or you could even broadcast it. And I'll show that in other videos from the NAR lawyers and the settlement agreement itself. So these are the scenarios, but I imagine all listing agents, except for the uttermost extreme circumstances, would want to start off with no buyer compensation being offered for now. So they're concerned about price fixing. They've raised serious concerns about the buyer-broker agreement requirement. And that means the requirement, it's by law right now in California, you have to have a buyer-broker agreement, but it doesn't have to cement in the price, the terms that are going to lead to payment of an agent. And it certainly doesn't say you must agree to the exact amount of compensation you'll receive ahead of time. That's not the law. That's NAR's way of trying to keep cement in real estate commissions and get around these class action suits. So, okay, so that was their link to that. So the problem is that I see, the major problem is that many realtors will ask their clients, hey, I'd like to get paid 2% or 3%. By the way, it should be a flat fee if you were smart as an agent or a seller or a buyer. You should be agreeing to flat fees because you want to eliminate one of the concerns is that you don't want your agent to be incentivized to have the buyer's agent, be incentivized to pay more for the property. So if they multiple offer situation and the buyer pays $100,000 more, that's $3,000 or $2,000 in the agent's pocket. The DOJ alluded to in sort of a snarky comment that they think the buyers would be happy to know their agents are incentivized to make them pay more. So why not just make it easy and make it a flat fee? That's the lawyer in me talking. Now, the settlement. I'm sorry, let me get my train of thought back here. When a buyer agrees to compensate, let's say $20,000 to the buyer's agent upon a successful close, the buyer agent then says, well, let's say that we're looking at properties and the seller's not offering any buyer agent compensation, or the seller is only offering $10,000 or $5,000 or $3,000 for attorney's fees. Are you going to want to pay me the $17,000 out of your pocket at closing? The vast majority of sellers will say no, they'd rather buy a more expensive house or put a floor in. So the agent is then trained to say, I've seen the training on the internet, well, don't worry then, I'll only show properties where they're offering to pay buyer agent compensation, or that it's at least negotiable to the levels of payment here. And but don't worry about those other houses, we'll still find you a great house. So right there, because of the way buyers and buyer agents interact, and the buyer agents are forcing the buyers to pay them 2 or 3% ahead of time, they're going to not show the properties that aren't offering that. That's steering. That's a very point. It was one of the major points that was supposed to be fixed up in this litigation, and instead it's being institutionalized because of NAR. I mean, it was brilliant on their part to make their agents do this, because that is when they have most leverage, when people don't like, they might not know the area, they might not know the market, they want help, they don't want to buy directly from the listing agent because they want someone on their side. All the marketing and the training, and there's truth behind it. I mean, that's why it's effective. And so the moment of buyer weakness and listing agent strength, that's the time they're locking down their price. It's brilliant. And then, okay, the easy thing would be, well, then don't be a NAR realtor. But then they're saying in the MLS, if you're going to be an MLS participant, and I've been struggling for a definition for that, it looks like MLS participant is anyone who's paying the membership fees and has access to the data, which is a terrible definition. I realize, because it's so vague right now, they could redefine that in a way to fight a lawsuit. The lawsuits are getting sued. But right now, like, I personally, if I had buyer's agents in my office, I would cease being a NAR realtor. I would use my own forms, and I would tell my agents, you work with your buyer in whatever way is best for your buyer and your business. You work that out. You don't have to lock him into a price ahead of time. But then, in theory, I might not be able to access the data on the MLS, and therefore none of my agents working under me as a brokerage would. So, as long as this MLS participant thing is defined as potentially being anybody getting data from the MLS, or anybody subscribing to the MLS data, then there's what could be called a RICO, or a criminal conspiracy, going on to force buyer's agents to use this very oppressive tactic of making people agree ahead of time before they even see a property. And they can't even say, I will reduce if necessary. Like, they're supposed to be locked in, it seems. And it's just crazy. So, these other things you don't really need to worry about. They're just saying they don't want the NAR to be able to defend themselves and say, oh, we've already worked all this out. It's res judicata. They're saying, no, that's not what we believe. We don't believe this is res judicata. That's this part. Settlement could limit competition for buyers among buyers' brokers. DOJ was concerned the settlement could allow brokers and prospective buyers to sign agreements that can harm buyers. I think these things are all very true. I mean, this locking in with the MLS is just, it's crazy. Okay, so now that's the background. In the next video, I'm going to go over the form and the training. This one got a little long, so let me just say the form's already made. It's available at, here, let me just pull it up right now. Form.gettingclientspro.com. I think if you just go there, the rest of it will get filled in. At least that's how I hope I set it up. Yes. And this will probably be, this is a previous iteration, part of it. This, I think I'll just make a short video explaining the form, and I'll explain, and then I'm going to have, I think I'll have 2 buttons, one for agents and one for sellers. So my name's John McConnin. I'm licensed in California. Many of the things I said would apply nationally, but if you're outside of California, you may want to consult with an attorney after getting this form. Thanks. Talk to you later. Bye.